Look at the definition of record as provided under section 2I of the Act, and you will notice that record has been specifically defined over here, and the word record is a collective denomination of written details of a subject which may include the maps, drawing and other related matters. Record may have different forms. It is important for us to understand. One, it may be in the form of a document. The term here may mean a piece of paper or set of such papers which may contain the details of a particular thing or a subject. It may be in the form of handwritten, printed, typed paper, map or drawing. Second, you will also notice that a record can be a manuscript. What is a manuscript? It may denote the original form of a handwritten document or a map or a drawing. It may also include issues like what is there in a file. File, it stands for a collection of paper or papers pertaining to the details of a subject. One file may contain many documents interconnected to each other on the same subject or with reference to that subject. Normally, one file contains interconnected documents and other details including handwritten or typed notes on the same subject. Second, you will notice that record indicates in also electronic form of a document in the form of a microfilm, microfiche and facsimile copy. The record regarding a particular subject may be reduced to an electronic form, very important. But since even in electrofilm form it contains the content of the original document, therefore in this shape also these are part of the record notwithstanding its form. The original information continues to be part of the record. Next, when these electronic documents are reproduced in the form of images, these remain still the part of the record. So either electronically record can be asked or in the physical copy. Whether the images are reproduced in original shape or in a reduced or an enlarged shape or form, the same shall remain part of the record. Okay. Also, when we talk about record, it is important to look at any other material produced or generated through the computer or any other device pertaining to the original content of the document, manuscript or file shall remain part of the record. So even original documents generated through computer and other devices relating to the subject may become part of the record. Record, thus, it may be said, basically denotes the details of the descriptions of a subject, which may consist various documents in various forms, shapes and size. All these things taken together may be called as record, and individually also such documents are part of the record. The definition of record under the Right to Information Act takes care of the latest technology available in the maintenance of the record, especially digital or electronic. It takes the right provided under the Act to the remotest possibility of availability of information in any form. It broadens the horizon from written documents to anything that is there in modern technology. Next, let's go to the definition of what is provided as a right to information under section 2J. Friends, till now we have looked at the definition of information and we have looked at the definition of a record. Now we'll try and understand what does the right to information contain. What is this right about? What is the scope of this right? How is this right defined under the RTA Act? One would notice that right to information means the right to access information under this law which is held by or under the control of a public authority. It is either held by the public authority or is within the control of the public authority and includes the following. Interestingly, section 2J says that right to information is not limited to accessing documents and record, which is definitely part of the right. You can access document and records either in hard copy or in soft copy, but it also includes the right to inspection of work. Now, inspection of work is a very important component of ensuring transparency and accountability of the public authorities. And hence, it is not only accessing information in material form, in a record form, it is also checking the kind of work that public authorities are engaging in. The word inspection here very clearly means monitoring and supervision and a physical assessment of the material work that is being executed by the public authorities. And hence, when any public work is being executed, the citizen can seek inspection of the same. This is part of the right to information. So, what the RTA Act 2005 has done is that probably it has expanded the scope of the right to know. Constitutionally, as we see under Article 19(1)(a), the right to know entitled only the right to access information. Here, under the Right to Information Act, there is an additional component of inspection of work which probably was never accepted or enumerated under the right to know constitutional jurisprudence. Second, while inspecting work, while inspecting document and record. Please note, inspection of work, document and record is something that you can definitely do without applying to get copies of the said information. You are also entitled to take notes, extracts of the same. So taking notes on inspection is some kind of a right that is given to you. And very importantly, the third component here is the certified copies of the documents and record. It would be the obligation of the Public Information Officer to certify the documents and record as true copies when provided under the Right to Information Act. So obtaining certified copies of the document and the record is also a matter of right that is provided under this legislation. I repeat, taking notes on inspection of documents, records and work, taking extracts if necessary, or applying for the same, and third, applying for certified copies of the document and record is a matter of right to information. Very important is samples are definitely included within the definition of information. However, taking certified sample is under the right to information, which means again the Public Information Officer cannot only supply the sample, but he has to certify that the sample is a true sample and has been certified accordingly, so that the citizen is satisfied that there is no fabrication of the sample as the case may be. Last but not the least, under the right to information, obtaining information in the form of diskettes or floppies, tapes, video cassette, or in any other electronic mode, or through a printout, where such information is stored in a computer or any other device. So information in soft copy, information in floppies, tapes and video cassettes, if any information is stored in this form or in any other electronic mode or has been taken as printout from a computer system, they can also be accessed under the Right to Information Act. And hence, the scope of the right here is far more greater in its application as against probably pre-2005, which probably was something that the judges interpreted under Article 19(1)(a). And then the only mechanism was to approach through a writ in the court to access that kind of right to know and the limitation of why this information is being sought. So the right to information definition is an all-encompassing one. It's an all-empowering one, and it empowers citizens with various aspects of exercising the different nature of responsibilities that is required to act as a watchdog on government functions and government functionaries, to actually look at some kind of a monitoring system to check corruption and to ensure transparency and accountability of the system as well. Now, if I look at the word inspection, it is important for us to understand it means inspection of work, document and record, and which means that these can be closely monitored and followed carefully by the citizen. Here you would notice that no document is obtained in any form, but the information is simply seen and scrutinized in a particular angle with a due care and with a specific purpose. So seeking documents, records are one. Inspection has a different purpose altogether. And in inspection, you don't have to pay for the information fee per page. You'll just go and see the information. You'll probably scrutinize the information as the case may be. And that is what inspection is all about. So the right of inspection very clearly is a right that citizens have in a democratic system. And I think it's a very important component of the right that is being provided for. And I think inspection very clearly means on spot, the citizen has the right to check whether the work is satisfactory or not, or whether any kind of a dispute or grievance has to be escalated, as the case may be, for unsatisfactory work. You may also note that inspection of work is about the quality, quantity, and ingredient used in the work, and the same can be scrutinized by the citizen. For example, any work, whether it is pertaining to an office or a construction activity, may be inspected in its various dimensions. Any document or record that has granted that work, that is available in any form, may also be inspected. That means a contract may be inspected. The work schedule can be inspected. Thus, the inspection of work document and record does not involve taking the physical copy of the document or the possession of the material, but is more or less a mental exercise to have a view of the matter. Extracting notes or taking notes is also part of the right to information. So taking notes may mean noting down certain information from the documents inspected. In this process, the copy of the document is not obtained, but the required information is noted from the documents perused. It may include the original extracts from the main document. Similarly, the right to information also allows the photocopy of the relevant document and record. So after inspection, I am entitled to seek this document and record as well. The photocopy of the document contains the entire information of the document as such. Apart from the document, the details of a physical activity or a work in progress may also be noted down in this process. In a case before the Central Information Commission, it was suggested that during inspection, the citizen can apply for a video camera or a video recording if he or she wishes to do the same. And if the place and the inspection is such that a video camera can be entertained, the public information officer may not only provide for inspection, but also provide for the videography of the inspection as well. So these are possibilities based on the citizen's request and the public information applying the mind of whether videographing or video recording of the inspection can be allowed and can be permitted or not. So these are certain aspects under the right to information law. Interestingly, kindly note, in exercising the right to information, one will have to look at the rules, because while we say that right to information is a right, it is not a free right. There are fees that are applicable for the exercise of this right. For example, when documents are taken per page, the rules, the central RTI information rules, prescribe a fee of 2 rupees per page. This is the information fee that will have to be paid for exercising the right to information and obtaining copies of the said document or record, as the case may be. Similarly, there are rules that prescribe fee for inspection. The central rules say that the first 1 hour of inspection is free, and this clearly entitles you to follow the fee part of the rules in trying to prescribe what fee is applicable for what exercise of the said information. The right to information also includes taking certified samples of a material. As we know, the purpose of transparency and accountability is to contain corruption, and it authorizes citizens to take sample from the material being purchased or used by the public authority. Therefore, it is an effective way to check the quality of work being executed by various public authorities. Right? It also indicates and denotes that the electronic mode of right to information, apart from inspection and the photocopies, the information may be obtained in various forms, which are probably the forms that will be currently required. For example, as we speak today, I don't think disks and floppies are being used in our computer systems and networks. Even video cassettes, for that matter, are probably out of technology and out of date. Today, probably what we would be speaking about is pen drives. We will be speaking about DVDs or any other form. And I think there is enough scope for modern technology to be infused in the right to information law. The quantum of information and the thickness attached are something that are very important. And you will notice that when soft copy of information is sought, large information can be gathered in a very small space, and this can be accessed by application of latest technology, include hard disks and others that are compatible with public authorities and its functioning, and that are also compatible with ensuring that the right to information is protected and is provided for under this law. The next aspect for discussion, after we have discussed all the important definitions that are provided in section 2, is to move to section 3. Section 3 is about who can seek information under the Right to Information Act. Section 3 very clearly says that subject to the provisions of this law, all citizens shall have right to information. Now the interesting part of section 3 is it says that all citizens shall have right to information. However, this is subject to the various provisions of this law of whether the information can be provided or not provided, and what are the obligations and what are the liabilities are something that the citizens have to do in terms of exercising the right to information. Now, if one looks at section 3, you will notice that right to information is an individual right. It's a freedom to seek public information, where the information means a material relating to an affair of administration or a decision of a public authority. However, please note, when this is said as a right, it is an individual right. It's an individual freedom. It's not something that is a collective right or a collective freedom that is to be exercised. Neither is it a group right. Neither it's a right that is to be enshrined through incorporation of entities. It is undisputable that in a democratic policy to ensure and facilitate the continued participation of the people in the effective functioning of the democratic process, people must be kept informed of the vital decisions taken by the government and the basis thereof. Thus, right to seek and receive public information becomes a pillar of a democratic setup. In this regard, every citizen is eligible to make an application to obtain information from a public authority, and includes the right of inspection, right? So the right which is given to citizen is a right that he can entitle or exercise in terms of taking soft copy, hard copy, inspection, certified copies, certified samples as well. So this is something that a citizen can exercise altogether under this law. Interestingly, the main issue for discussion over here under section 3 is who is a citizen. Interestingly, the definition of citizen is not provided under the Right to Information Act. Now, if you see the definition of citizen under the Citizenship Act of 1955, citizenship is often granted to a natural person, right? And it does not or is not granted to a juristic person. However, the difference between a person and a citizen has to be taken into account. For example, if one reads section 6 of the Right to Information Act, you will notice that the word in section 6 that is used, any person can make an application to seek information. The word used in section 6 is a person, whereas the word that is used in section 3 to give the right is citizen. Now, person includes both a natural person, that is me and you, and a juristic person, that is an incorporated entity like a company, a partnership, a university, or a registered non-governmental organization. So the definition of person is far wider than the definition of citizen. The application of rights to a person are far wider than the application of rights to a citizen. If one goes to section 3, subclause 42 of the General Clauses Act 1897, then you will notice that the person includes both a natural individual and a registered individual, or a juristic personality, or an artificial person, as we would want to call it. Every citizen is a person, but the vice versa is not true. That means artificial or juristic persons cannot be citizens. So a company does not have a citizenship, a university does not have a citizenship, a partnership does not have a citizenship. An association of individuals may not have citizenship if they are registered as a non-governmental organization. The juristic person cannot generally enforce fundamental rights, right? Especially when you talk about certain fundamental rights that are applicable. But the individual citizens forming legal entities can invoke fundamental rights. So a juristic person on its own cannot invoke a fundamental right. It has to be invoked through the individual, as the case may be. And hence, in the case of Indra Grover versus Ministry of Railways, a case decided by the Central Information Commission in 2006, it was held that persons applying for information under the RTA Act should apply as natural and individual persons only, Because the right is given to citizens, only natural and individual persons can make an application. Corporate bodies and juristic persons cannot apply for information under this act. That's a very clear proposition here. If a person applies as a representative of the corporate body, then he is not entitled to the information required under this act. Right? So, the Right to Information Act is available to citizens in his individual capacity, not in his official capacity. The right to information is applicable to individuals and not to body corporates. This is very clear in terms of the interpretation and the application of Section 3 of the Right to Information Act. So, I think Section 3 is an important proposition while going ahead in trying to address the fact who can seek information under the Right to Information Act. Does the word citizen include NRIs? I presume yes. Non-resident Indians are not staying in India, however continue to hold the Indian citizenship. They may be working abroad, they may be residing abroad, but they continue to hold the Indian passport and the Indian citizenship. That's why they are called as non-resident Indians. And hence, NRIs are also entitled to apply under the RTA Act. They are continuing to hold the citizenship and they can access the Right to Information Act. A citizen under the Constitution Part 2 that deals with citizenship can only be of a natural born person, and it does not even by implication include a legal or a juristic person like the corporations or the banks as the case may be. Right? So this Prabhakar versus PIO case, the MAPSA Municipal Council Goa is again reiterating what was held previously as well. Now, if one looks at Section 2(1)(f) of the Citizenship Act of 1955, it defines that a person does not include a company, an association, or body of individuals, whether incorporated or not, for the purpose of the application of citizenship. Okay, so this is something that one will have to take into consideration about the right under the Information Act. Generally, fundamental freedoms to citizens only. The issue came before the Apex Court in the State Trading Corporation of India Limited versus Commercial Tax Officer. The Honorable Apex Court, the Supreme Court, had clarified that State Trading Corporation is not a citizen. So these corporations, even public sector corporations or banks, are not citizens, and necessarily they would not have fundamental rights as enshrined in Article 19, which are supposed to be given only to individuals and not to body corporations or body corporates. So I think this is now very clear that only natural individual persons in their personal capacity can apply under the Right to Information Act.